Alright guys, this is your top flight attorney Adebayo Adesina coming to you from Chicago, Illinois by the lake. I stopped at Vawa number 4. Vawa requirements. Under Vawa requirements, we have 10 subcategories and I'm going to go through them real quick. The requirements, as I mentioned earlier, that you have to be either married to a U.S. citizen, in other words, a spouse of a U.S. citizen, child of a U.S. citizen, or parent of a U.S. citizen, going to be explained in this subcategory, number 4. Now, number 1 is you have to be married to a U.S. citizen or lawful permanent resident. That's self-explanatory. Number 2 is you could be intended to get married to a U.S. citizen to apply for VAWA. And this is a unique circumstance in which you plan to marry a U.S. citizen but then found out that they were already married. You found out they were already married. And in that case, if the U.S. citizen is abusing you, we can still file for your adjustment of status through VAWA. That's number 2, intended marriages. Number 3 is termination of marriage. Now, even if you have been divorced from the U.S. citizen, you can still apply to adjust your status through VAWA. The only requirement in this instance is that the divorce cannot be over 2 years. So you can be divorced from the abused spouse, but the divorce cannot be more than 2 years before you apply for VAWA. Number 4 is parent or child relationship. As we mentioned earlier, you not only can apply for VAWA if you're a spouse or U.S. citizen, you can also apply if you're the parent or a child of a U.S. citizen. Number 5 is parent of abusive U.S. citizen or permanent resident. Follows from number 4, the parent, but the U.S. citizen or permanent resident has to be abusing you for you to qualify for VAWA. There is also a residence requirement. For this, I think I'll go to my notes. Number 6, there's a residence requirement, and there are 2 prongs to the residence requirement. The first one is to qualify for VAWA, you must reside in the United States at the time the VAWA petition is filed. If you do not reside in the United States at the time the VAWA petition is filed, you must be able to show that the abusive U.S. citizen or lawful permanent resident is an employee of the U.S. government or member of the uniformed services of the U.S., or that the abusive U.S. citizen or lawful permanent resident subjected you or your child to extreme cruelty or battery in the U.S. at some point. The second prong is that if you do not reside in the U.S. to qualify for VAWA, you must have resided with the abusive spouse, U.S. citizen or lawful permanent resident at some point. You must have resided with the U.S. citizen, abusive spouse, or lawful permanent resident at some point. You do not need to currently reside with the abusive spouse or lawful permanent residence. Also, your residence with the abusive U.S. citizen or lawful permanent residence does not need to have been in the U.S. I've had questions about this before, and sometimes the abuse takes place in a different country. Maybe the U.S. citizen is a member of the armed forces and they're posted in your country, and that's how you came in contact with them, and they promised to file for U.S. green card on your behalf, but then they were abusing you at the same time. And you may think you do not qualify because you never lived in the U.S. Well, you do. If the abuse took place outside of the U.S., the United States territory, but it was carried out by a U.S.